This short video addresses the changing way estate planning attorneys and gun owners use NFA trusts. Attorney Matthew Wenzlau addresses the limits Firearms Act imposes on specific guns and accessories, what items are affected, how the law has changed, and what to do to determine the best course of action for your clients with firearms collections.
If you have less than 18 inches on some sort of a gun, but it's a rifle and it's not a handgun. So we're not talking about pistols. We're talking about that kind of like sort of assault weapon world or mid between pistol and rifle, or a shotgun that's been sawed off or whatever. Those are usually going to be your NFA items, meaning, hey, you got to pay it. You may not be able to even have them, but if you can, you're going to pay a tax and you're going to fill out paperwork saying, I have this gun, I'm responsible for it. And by the way, I'll alert you if I leave my jurisdiction or whatnot. You can see from 1934, a $200 tax was levied on these things, and it was to try and prohibit these sorts of items. And so the concealability became a big deal. The barrel length became a big deal. And here in 2020 to 2025, the barrel length coupled with what else is attached to it has become a big deal, right? And so from that perspective, what we're saying is, okay, what is it that we're doing and how do we analyze it? The NFA Act of 1934 is going to be there. To possess these items, here's your little list: pay the tax, register with ATF, submit photo and fingerprints, and obtain the signature of the chief law enforcement officer. The real reason the trusts ever came to fruition is because there was a loophole that says if you have a trust, you don't have to worry about number 4. You don't have to get the CLEO's signature on this bad boy because you have a trust. But the way that it's panned out now is that, okay, fine, we don't even have to have the signature. You just have to alert him or her. You send a letter to them saying, hey, by the way, I got the suppressor, or I've got this short barrel rifle or whatever. Here's my letter. But now if it's in the trust, you have to have everybody who's involved in the trust be qualified, okay? And that's the part where it gets a little sticky. Trustees come and go. People involved in the trust come and go. Beneficiaries may shift. And that's where potentially you get yourself future work, right? Like, hey, you got to change in beneficiary every 3 months. Okay, cool. Or you got to change in stock of guns you have. Cool, we can go ahead and update the trust. But it may not be as useful as you're thinking because number 4 is really no longer relevant.